Hi there, folks. This is Ed Correa. We're still getting some things together and allowing people to log in and get situated. We will start right on time, and I've got about a minute till broadcast time. So hang in there. Okay, I'm coming off of mute here, and we're coming right up on 10 a.m. It's 10 a.m. and time to start, Alan. Good morning, and thank you for joining us for another in our series of educational webinars. As usual, this webinar is being recorded, and I'd like to make a special request that if you have questions during the webinar, that you type those questions into the sidebar of the webinar control console where it says questions. I will be watching for your questions during the webinar, and I will make every effort to ensure that they're answered during the webinar. And I'll remind you of this one more time. So let's get going. Oops. There we are. Okay. So today our speakers include, first of all, myself. I'm Ed Correa, founder and CEO of Sagacent Technologies. I've been a technology junkie for 41 years now. So I beat Alan by 1 year. My company, Sagacent, is a leading technology management firm here in Silicon Valley and getting close to wrapping up our 18th year in business. Sagacent focuses on businesses, frequently professional service firms, who really care about business operations, business continuity, data security, and compliance with any regulations that their industry may be subject to. And now I'd like to introduce my special guest, Alan Foster. Sorry for the count. Alan Foster is the principal of the Foster Law Group. He has been practicing law for 40 years, and the last 12 of which he's been running his own Silicon Valley law firm, the Foster Law Group. Alan helps all types of businesses, frequently to start and grow over time. But I understand from some conversations with him, most recently he's been helping a lot of SaaS, software as a service companies, and e-commerce businesses who are strongly affected by GDPR and AB 375 that we'll be discussing today. But the real reason that I invited Alan to join me today, besides, of course, that he's an expert on both laws, is because Alan makes legal business issues become clear, less complex and understandable. He speaks our language, and he's never pretentious. I've always found his legal advice to be, on any subject, eye-opening and easy to understand. Thus, I feel very privileged that Alan has taken me up on my offer to join us today and take up his valuable time to enlighten us. So, our goal today is to assist our webinar attendees with getting acquainted with the legal requirements of both the European Union's General Data Protection Regulation, or commonly called GDPR, and California's Assembly Bill 375, or I'll keep referring to that one as AB 375. And we will explain some of the similarities and differences. I will point out that when we put the slide set together, we decided to put this together into two sections. The first section is solely on Europe's GDPR. The second part will cover AB 375. These get a little bit complex, and we felt it was best to split these up. A little bit about our slide set. You know, it's often said when you're going to have slides, have no more than 3 to 6 bullets and keep your number of words to less than 10. We're breaking those rules. The idea with these slides is to be a reference for you later to take away. So there's a ton of data. You don't have to read it all during this webinar. Okay, but that way you understand what our intention was to do. So a little bit more. The goal of the webinar is to give you a somewhat basic understanding of the GDPR and AB 375. This is not the end-all be-all of your education. It should be just a starting for you. Hopefully we understand that you, or we hope that you understand a little bit about the regulations, and that you might be able to see if you have to take future actions or could see a way to exclude yourself from either regulation. We understand that there's a lot of hype out there on these laws. Before Alan and I went live today, we were talking about many vendors who are offering solutions around these. You have to be a little cautious. Anyway, as a final reminder, I'd like to make a special request that if you have questions during the webinar, that you please type those into the sidebar of the webinar control console where it says questions. I will be watching for your questions during the webinar, and I will make every effort to ensure that they're answered during the webinar. Thank you very much. First up is our discussion of the European Union's General Data Protection Regulation, or GDPR. Alan, you wanted me to specifically state that no one has all the answers yet. Why is that?
Well, for U.S. companies, and this is really the focus of the webinar this morning, is the company that, let's say, is located in San Jose. They don't have a facility in Paris or in Munich. So they're trying to wrap their mind around, okay, what are these two new laws? A lot of U.S. companies have been so busy dealing with the other challenges that they deal with on a technology and business level that they really haven't had an opportunity to learn a whole lot yet about the GDPR. So the purpose of today's program is to help you get a step up on most businesses in the U.S.
Alan's not understanding my. Alan, when you're not speaking, hit the button.
Oh,
we have an assistant listening in, and she says, "Turn off our mics when we're not speaking." So you're off now. I'm on. It would help with the echo. Okay, we're learning as we process. So let's get started. Alan, I understand that the GDPR became effective May 25th of 2018. Can you enlighten us on what the GDPR is?
Well, the GDPR was a response to data breaches that have occurred, that we've all heard about, breaches that have occurred in various countries. Yahoo had a massive data breach that wasn't even disclosed for a few years, but it's designed to reduce the risk of data breaches by giving data subjects or persons in the EU more control over their personal data, and it imposes new obligations on companies that either control the processing of that personal data or process the personal data at the instruction of the general contractor, so to speak, or data collector, data controller.
Okay. So how can you explain how a U.S. company comes to be ruled or under the control of a European law?
A U.S. company, and again, I'll use the example of a company that has one location in San Jose, but perhaps has a website, they can come within the scope of the GDPR in two ways. If they either offer goods or services to individuals in the EU, or if they use cookies or other devices to monitor visitors to their website.
Okay, but can you define cookies?
Cookies would be any device that monitors the movements of a visitor to that company's website?
I'm looking for a little bit more information on cookies because I think that really confuses people. So I understand that from a tech perspective, cookies are usually to help people understand that they've already been to that website and get logged in easier. But there's also ways to capture data of the user. And that's, I think, what the GDPR is focused on. What are we capturing of that user in this so-called cookie just because we visited a website?
The thing that's being captured is the IP address and similar information. And under the GDPR and under the California law, an IP address is considered to be personal data.
Okay, that makes it a lot more complex. And here's my slide that I read wrong. So personal data that US companies have to be aware that they might be capturing that's going to throw us under the jurisdiction of a European law.
The definition of personal data, actually under both laws, but under the GDPR, is any information as to an identified or identifiable individual that could disclose who that individual is. And as we will see on the next slide, that is a pretty extensive list of types of information. It could be the person's name, the person's email address, IP address, and similar information.
So if I don't intentionally target or try to sell to European businesses specifically, I'm not subject to this.
That is basically true, but it depends also on what your company's marketing materials and your website say. And as we'll learn a little bit later on in the program, there are ways to, scoot your company outside the scope of the GDPR by modifying your marketing materials and your website.
Okay, sounds good. One moment, please. Technical issue. Okay, Alan was telling me that I'm reading the wrong slide at the wrong time, which is apparent because I'm asking questions about the wrong thing. That's the challenge with having multiple monitors in front of you. Anyway, so Alan, you've already answered this one about the personal data. I apologize. But it sounds like there's a lot of different data that people consider personal, and you're basically pointing out that we have to be very aware of what we're gathering from these people.
That's really true, and in both of these laws, you may not think you're dealing with personal data, but you are if it could be used either by itself or perhaps with other information to identify an individual. And in this case, we're focusing on individuals located in the European Union.
Okay, how do I know if my company is processing personal data? Most of the businesses that I talk to, the business executive he's running the business, trying to grow the business. They're not really looking at the minutia of going on.
Well, the short answer is if a company has personal data in its possession, it's processing it. Because as you can see from the slide, if you obtain personal data, if you're holding it, you're storing it, you're adapting it, even if you're destroying it, you are processing personal data.
So I'd like to discuss a couple examples. Example number one, if my company has a marketing list and it happens to have EU citizens on it, therefore I have their data.
That's correct.
And if I have a website which EU or European Union's citizens visit, and I'm capturing things like their IP address to know where the visitors to my website are coming from, then I have their data.
That's correct.
then I have their data.
That is also correct.
So continuing that line of thought, if I have a website, but I specifically don't use cookies and I don't use some third-party tool to capture IP addresses, then I could possibly exclude myself.
Yes, possibly. That would take care of the cookies angle, so to speak, of being brought within the GDPR, but then we would focus on your website and other marketing materials to see what they say.
Unfortunately, that also helps defeat the benefits of having a website, because I'm using that as a strategic marketing tool. I want to see who's interested in my company so I can follow up. So that kind of defeats it, but it doesn't tell us whether or not I have EU citizens within my databases. That's something I have to be very aware of.
That's right. And you know, the GDPR and the California law are going to require companies to do, in some cases, a very painful gut check of, well, how important is it to me to use cookies on my website? How important is it to my business model to have personal data?
Does the GDPR only apply to businesses providing goods and services? Are there any individuals who could be subject to this?
The GDPR applies to both businesses and organizations. So by that, it could apply to, for example, nonprofits, in contrast to the California law, which only applies to for-profit enterprises. But what's interesting, Ed, is that the GDPR, if a company falls within its requirements, it could even be a one-person business. I'm thinking of a client I have who has a great website where he blogs about the importance of eating organic food. And if he has certain content on his website, or if he is using cookies, this one-person company is going to be subject to the GDPR.
And I understand from previous discussions, those things can be dictated by us, to us. So I'm alluding to the fact of the next slide. So you're going to tell me that European residents can then tell me how to manage my data.
That's right. And if we all just take a look at the slide, you'll see that it applies to the data subject and has a lot of rights. They can have it corrected if they think it's wrong or outdated. But take a look at the one where the data subject can change the way that the data is processed. So in that case, you've been managing the data in a certain way, you've been doing a good job, but then you get a request to change the method, and you've got to make a change in your operations, in your data management operations. That could be challenging.
So just to clarify, this isn't really my data. I consider it my data because it's on my systems, but if it's about them, then it's their data. I'm talking about European Union citizens, and I have to do what they ask.
Well, the philosophy of the GDPR is it's all about them. In fact, the philosophy of the GDPR is that personal data belongs to that EU individual.
And I'm imagining this is going to have far-reaching effects on some of our large Silicon Valley companies.
It's going to be huge. In fact, when the GDPR effective date hit, even Google had to admit that it did not have its act together and was not ready to be in compliance. So everyone from the smallest companies to the largest is sort of scrambling to make sure that they're in compliance with the GDPR if they're subject to it.
So I'd like to talk a little bit about the requirements of the GDPR. I understand that there are data controllers and data processors. What are the key duties of those people? I'm assuming those are people.
They're typically a company. The data controller is the company, I'll just talk in terms of companies here. It's the company that decides what data is going to be collected and how it's going to be collected and how it's going to be used. The data processor, think of the data processor as kind of like a subcontractor who's retained by the data controller to actually do the processing. It's very important for those of you out there who might find yourself in the position of being a data processor that your contract specify that you're doing that processing solely at the instruction of the data controller, and that the data controller will indemnify your company if a liability arises.
There we go, back on again. A slight tangent. So when we first approach any business as a possible client for my company, to be honest, the vast majority of them have no controls of their data, or more correctly, they have no awareness for their data. They don't know where it is. They don't know who has access to it. They don't know how it's secured. They don't know when it was backed up or how it's being backed up, and they don't know how far it goes back. And I'm getting the impression from some of these slides that you have to know all this stuff in order to comply with things you might be required to do because of the GDPR.
Yeah, this is, Ed, you really hit on the key issue from an operational standpoint, and it's going to absolutely revolutionize data management. It's going to be essential that a company be totally on top of what personal data it is taken in, where it's being stored, who it's being shared with, just so the company can comply with requests from data subjects under this law and also under the California law.
So you just said a word that kind of perked my ears, shared with. So maybe I'm using outside vendors to help me in my marketing, and I send them a list. Might that put them under this?
Yes, very much so. Let's say if you have a firm helping you with your marketing, that firm would probably be considered a data processor under the GDPR. In other words, they've got personal data in their possession. And I think with the sharing of data, quite often in the past, companies have said, hey, I want to share some of this data with this strategic partner of mine. They've really helped us build our company. It'll be a win-win situation. It'll help them. Well, now with this law, the GDPR and the California law, sharing of personal data, there's a real price that comes with it and responsibilities.
So I'm imagining different businesses of different sizes have options on how they're going to manage their data to be compliant with the GDPR. If you're a smallish business, maybe you're going to outsource those duties. If you're a mid-sized business, you might say, you know what, we're going to give those duties to our CFO. He's going to get some training so that we can comply with this. And if you're a gargantuan company, maybe you're going to develop your own internal department. Can you speak to that?
Yeah, it's, the GDPR applies if the company falls within its specifications. It doesn't matter if you have one person in the company or if you have 10,000, 10 million. I guess there's no company with 10 million, but yes, every company is going to find their own way to comply with the GDPR and the California law. And in many cases for smaller companies, yes, they'll be outsourcing some of the functions, but also some of the small companies, small to medium companies that may be listening this morning to our webinar, you may find yourself in a position of also being a data processor. So you may be working under the instruction of a data controller.
This is sounding quite complex, but here comes the part that I'm the most apprehensive of. I hear a lot of people talking generically about fees, but I don't hear a lot of specifics. What are the penalties and liabilities for failing to comply with the GDPR?
The maximum penalties can be severe. Let's say if you have an intentional violation of the GDPR and there's quite a bit of damage done, the government fine that you can be hit with from the EU is up to the greater of 4% of the company's revenue, let's say the revenue from the prior year, gross revenue, I should say, or 20 million euros. So that's just the government fine. But here's a real interesting part of the GDPR that I think could be a real annoyance and could offer a lot of room for abuse. The data subjects have a right, let's say there's a data subject in Germany who thinks that your company has violated his rights under the GDPR. Under the GDPR, he has the right to get a free privacy attorney through a nonprofit organization in Germany who will then bring an action against your company in San Jose, and you need to deal with it indirectly and remotely. So if you think about how sometimes frivolous lawsuits are filed in the US, well, this is a whole new global dimension for potential abuse.
So one of my greatest concerns around your statement just there is attorneys, have a bad reputation that some of them are ambulance chasers, and they will want to fine people or create class action lawsuits so that they can get rich. My fear is that I may do everything I can to try and comply with the GDPR, but is there anything to protect me against unscrupulous lawyers that want to sue me?
I'm shocked by your statements about attorneys. I've never heard of such urban myths. No, this opens up the opportunity for some real rackets to go on globally. I know that's a strong word, but you're right. I mean, there are domestic American U.S. rackets with attorneys bringing frivolous lawsuits. But yeah, I think the main thing to do is, as we'll talk about a little bit later, see if your company is even subject to the GDPR. You may or may not want to be if you're on the, if you're kind of on the fence, so to speak, one way or the other. And then the main thing is to make sure that your contracts and your liability protections are in place.
Well, that's an excellent segue to the next slide set of ways of being excluded. I have to admit, I'm excited about the potential of excluding my company from the GDPR regulations. Can you enlighten us a bit?
Yeah, there are some ways that you can be excluded. Let's take a look at an example, and I've actually done this with a number of my clients. First of all, let's just say one of my clients, for example, is a company that has a SaaS solution for managing large-scale, very high-end event management in various countries. They were obviously subject to the GDPR, primarily as a data processor. So, sometimes you just know you're going to be subject to it and you comply with it and get everything in order. But a lot of companies, and maybe some of you out in the audience this morning, might be on the fence. Maybe you're subject to the GDPR, maybe not. But let's take a look at an example of how you can perhaps be excluded from this law. Let's assume that a company offers its goods and services, throughout the world through its website. Anyone in the world could see the website. And let's assume that visitors to that website are not monitored through cookies or other similar devices. Well, deep within the bowels of the recitals to the GDPR, that's the part of the GDPR that gives some of the rationale about why the GDPR says what it says. By far, recital 23 is my favorite, and it provides the most potential value for small to medium-sized businesses. And it basically says that, hey, look, even the drafters of the GDPR in the European Union, they realize that just because someone has a website, just because a company has a website where they offer their goods and services, it shouldn't mean that they automatically fall within the GDPR. In other words, you have to show that it is apparent, in other words, obvious, clear, that that company intends to offer goods or services to persons in the European Union. So it's important, we could look at the next slide. It's important then that we focus our analysis then on, okay, what does that company's website say? So again, if we're a US company, we want to avoid indicators on your website or other marketing materials, whatever those might be, either hard copy flyers or anything, that would indicate that you intend to offer goods and services to people in the European Union. So some of the things that we would take a look at is, does the website offer non-English language translations? Does it offer to translate the site into French, German. That's an indicator of intending to sell to the EU. EU-specific goods or services offered. Let's just look at kind of a fun example. It's not real, but it's kind of fun. Let's say if there was a 3-person company in Carson City, Nevada, beautiful northern Nevada. They're originally from the UK. So what they do is they offer tours, group tours, where the group can have an Old West, genuine Old West experience. They can go to Virginia City, go to Gold Hill, down the hill from Virginia City. They can go to Lake Tahoe. They can see the wild horses out in the beautiful countryside there. They can even go down 395 to go to the old Bodie ghost town, which everyone should take in. But at any rate, but their marketing approach on their website is, yes, we target people in the United Kingdom because that's where we're from. We love you. We're familiar with the culture, and we focus on that. Well, that would be pretty much in the bullseye. They would be subject to the GDPR because it's off. They are, obviously offering services to people in the EU. They may not care about it. They might say, hey, look, we'll comply with the GDPR. This is our business model.
Okay, well, let's have another example, and we'll pick on me. I like companies that are specifically headquartered in Silicon Valley. What advice would you give me?
I think the fact that you prefer companies in Silicon Valley and that you make that real clear on your website is a great start in making sure that your company is excluded from the GDPR. And that's what I would encourage a lot of companies who are on the fence, so to speak, to consider. Where companies can get into trouble is when they say things on their website that may not be all that important to their business model, but it creates an inference that they offer services in Europe. I'll give you an example, just a couple quick ones. I have a client that's a high-end mid-peninsula construction company. They do houses, I'm sure, for people who live in the EU but have second homes in, Woodside, Saratoga, places like that. But in looking at their website, the construction company's website, there was nothing on it that specifically said, oh yes, we cater to EU residents building them second homes. Similar situation with a business coach, consultant, and trainer who works with CEOs globally throughout the world. But in looking at her website and her blog that she has on her website, I was happy to see that there was only one thing that inferred that she does provide services to people located in the EU, and it was a real simple fix to just change that language. Similar with a Silicon Valley employment law firm and business law firm, and also an immigration law firm, where in connection with that one, the immigration law firm actually had a lot of Yelp reviews. They're all excellent, by the way, 5 stars all the way through. But you have to take a look at your Yelp reviews, anything that's linked to your website. And so I had to take a look to make sure that there was no one who gave this particular attorney a great review, gave their name, and then down below their address was Paris, France, or Munich, Germany. Even that could infer that that immigration attorney was targeting clients located in the EU.
So we've been pretty generic so far in our discussion of, what's a tip-off for being under the GDPR. We've talked about marketing lists. We've talked about your website. Increasingly, I'm seeing a lot of websites where they're specifically using it to sell products, goods, or services. And it's most common for people who are going to have this website is they buy a module or they get software as a service that's built into their website that outsources that whole function. And so it's processing the sale. And often those websites or those modules will be taking different kinds of currency. I would assume they also accept euros. Are you going to tell me that that's making a statement of intent to specifically support EU citizens?
It can, if that currency calculator or currency tool was directly on the company's website, that would be a strong indicator that it intends to sell to EU individuals. It's an interesting question. What if, let's say, a sub-processor is retained by the company, and sub-processors of payment are going to have full service capabilities? That person's going to be acting as a data processor. That could be a real close question. I think it might be an indicator that the company does have an intent to sell to people in the EU, but that's more of a mechanical and convenience factor. So that's kind of an open question in my mind under the GDPR, at least at this stage.
Okay, another question going at a different angle, but right around the time that the GDPR became effective or law, I think that was in May 25th, I began seeing websites having pop-ups that never had websites. And these pop-ups were telling visitors that they use cookies and that they use the data that's gathered for these purposes. Was this all due to the GDPR?
I think the GDPR was a very significant prod or nudging for U.S. companies to be more mindful of that. And I think the GDPR was the main reason for all those new things to be popping up. But in the months since then, it's going to be, I think it's pretty obvious that the trend is going to be toward more protection of personal data, whether you're in the GDPR or not.
But a little bit more specifically on those pop-ups, do you have any information on what should be included or put there today? I understand that things are going to change, and we have another slide we're going to talk about that, about trying to foretell of the future. But today, is it advisable that companies be working with someone to have some kind of informational pop-up telling visitors that are visiting their website certain things?
Yeah, I think it is a good practice. I think it's part of the disclosure, being more proactive with disclosures about what data your company is going to take and what you're going to do with it. I think a lot of these practices would be good for a lot of U.S. companies to start looking at. The disclosure factor too. I think just disclosing is important. And if a company is under the GDPR, it can process personal data only if it has a lawful reason for doing so. Now, the most obvious one is getting the person's consent through clicking, a conscious and obvious clicking of a box giving consent. And I think that's why you're seeing a lot more pop-ups, even though a lawful purpose could include the fulfilling of a contract that data subject is related to. There are other reasons where you wouldn't necessarily have to get consent, but I think you're seeing a lot of those pop-ups because, companies are trying to take the safest route, the most prudent, conservative route they can, and making sure that they're in compliance with the GDPR.
So my takeaway from that is, if I'm going to be subject to the GDPR and I'm capturing this data, having that consent recorded, because I'm already going to have their data, is a really, really good thing that they said that was okay.
Yeah, the consent, if you have that is a very important thing to do, because then your company is not in a position of having to argue, well, we didn't get consent to process this person's personal data, but we were using it for another lawful, reasonable purpose. And there's room for debate about what's reasonable. That's why there are attorneys in this world.
So this is pretty sticky, a little bit confusing. What should people do if they want to get more information?
Well, the European Union has put together some really good materials. I mean, very well written, rather clear, rather detailed, but they also have shorter versions. But if you want to do a deep dive, they have very detailed materials. So I would suggest that you take a look at the link on this slide. Ed, you mentioned earlier, I mean, I think it's the key issue of just making sure that your company knows what data, personal data you're taking in, where it's going, what's the map, where is it headed, where do we have it stored, and what are we doing with it, and who are we sharing it with, if anybody.
Okay, well, it's time to shift our discussion to California's Assembly Bill 375, which is very new and kind of came out of the blue. Alan, how and why did this law come about?
There was an initiative that was circulated and actually obtained enough signatures to be on the November ballot. It was a data privacy initiative that is even more protective or extreme or whatever term you'd like to use. But it would have been very difficult because under California law, new laws that are adopted by initiative are very difficult to amend or change later on. And in the case of any brand new data privacy law, there are going to be things that are going to need to be fixed. So big data, Google, Facebook, the usual characters, put together a group and they lobbied to get AB 375 passed through the legislature and signed by the governor in about 7 days. And in that way, it did head off the initiative that would have been a lot more difficult to deal with.
So hopefully it was a good thing that they moved that quickly. And tell us a little bit about who 375 targets and who's under its jurisdiction.
Well, this is real interesting. And if you take a look at the slide, 375 is a lot different than the GDPR as far as who's contained in it. It does apply to for-profit businesses that do business in California, that collect personal data from California residents, and either meet one of these three criteria. And you can see one of them's revenue, one of them's how many pieces of personal data, so to speak, that is collected in a year. And then the third one has to do with what percentage of annual revenues are obtained from selling consumers' personal data. AB 375 also applies to affiliates or co-branded entities of a business, as well as, and keep this in mind because this might apply to some of you in the audience this morning, subcontractors or vendors who process that data on behalf of the regulated business. There is an opportunity to be excluded from AB 375 if no part of the data collection or data processing or sale occurred in California. But California is such a huge economy of so many people that most companies, even if they're located outside of California, they have California customers. So that, that opportunity to be excluded, I think, is going to be a tough one to meet for most companies. The thing that I think is very interesting, if you take a look at that first bullet about who this law applies to, $25 million of annual revenues is a big chunk. However, as you know, a lot of small and medium-sized businesses hit that level, and this is gross revenue, remember? It's not net. So it strikes me that AB 375 could apply to a lot of businesses, agriculture, wineries, online sales, e-commerce, where really it's essentially a small company that doesn't really dabble in personal data all that much. They have some maybe, but it raises a question in my mind as to whether that is really a fair and justified provision of this law.
So some of my comments on this, you've already talked about the revenue target to be under this, but if you have a moderately successful website, it is not unusual to get 50,000 hits off of a popular website. So I'm imagining some companies that may be smallish, not doing that revenue requirement. Certainly they're not fulfilling the third bullet, which I'll talk about in a moment, but just because they track information on their website, they could be subject to the ruling.
That's really true. And you think about, I mean, there's some old jokes about how do you make a large fortune in the wine business. You start out, or a small fortune, you start out with a large fortune. So in the wine business, it's often described as a labor of love rather than money. But consider, I mean, you have a small winery, you're trying to produce some, good wine. and you're subject to this California law because maybe you've got over 25 million of revenue, or you meet the second bullet, let's say.
Well, certainly if you've got a wine business, I imagine those websites get a lot of hits, many of which are probably me. The third bullet derives 50% of its annual revenues from selling consumers data. I'm assuming that that's targeting big data companies that collect personal data about people, sell that data, process that data. Is that correct?
Yeah, that's correct. And of the three bullets, I mean, personally, I think that one has the most, merit in terms of
protecting people's data.
Yep.
Okay, let's talk a little bit about disclosures when collecting personal data.
Well, under the California law, there are certain disclosures that the company needs to make either before or at the time that the data is collected. And that is the categories of personal data that the business will collect and how the data will be used. And the other interesting thing is once a company has collected personal data, that business cannot use that data for any other purpose without notifying the individual.
So I've flipped to the next slide, which has one of my favorite requirements, a certain number of days that a business must act on a request. Can you enlighten us?
Yeah, these are requests that the individual can submit to the company, and the company is required to respond to the request. And if you take a look at that list, it's a lot of different things. It's a lot of different administrative and.
Before you continue, how do they have to respond? Is that via email, via letter, via website?
Either electronically or in writing. And typically, it's going to be electronic for the most part. And likewise, documentation of fulfilling the request is going to be primarily going to be electronic, using things like deletion logs and customary ways of showing that certain actions have been taken.
So you and I had talked offline again about companies that don't have awareness of what data they have, where the data they have it, who has access to it, how it's being backed up, where it is, and how old it is. And I'm imagining whether we're talking GDPR or AB 375, if somebody says, delete my data, you've got to delete that data wherever it lives and then tell them you've complied with it. I'm imagining the penalties are going to be pretty high if you didn't, or if somebody challenges you. Like, for example, how would a company prove that they complied with that if they didn't know where all the data existed?
Well, if they don't know where the data exists, they can't even find the data in the first place. But you're right. I mean, there could be no proof of compliance. But typically, the company would use customary means like a data deletion log or similar thing that they keep. But yeah, if you can't find the data in the first place, you can't comply.
And this is the slide I was alluding to a moment ago, the right to be forgotten. They can tell me, again, I made the analogy earlier, I said even though I call it my data, it's really their data, and if they tell me to delete them from the data, I have to comply.
That's right. And as you can see on the slide, there are exceptions for this situation. But if none of those exceptions apply, yeah, you've got to delete their data after you've found it.
Okay, and the next one is about a notice to opt out before personal data can be resold. I don't sell data, and I think a lot of businesses don't, but I imagine some businesses do.
Yeah, they do. None of my clients do, but that's true. I mean, this is the reselling area. This is the real sensitive area. And yes, the individual has a right to opt out through a simple procedure. So companies have to be able to provide that simple procedure, typically through their website.
Well, that's good. That part of it makes me happy. And you said that the big companies in Silicon Valley or along the West Coast had a lot of input on this, so hopefully they designed something that's doable.
Well, there's a bit of a debate. I mean, there are people out there that said that the initiative was the more pure approach to this thing, and that big data is trying to water things down. But this law, this California law, is not insignificant. It's a very significant new burden. My concern, again, is going to be how does it affect the companies that are really on the fence, that may have 25 million in revenue, but really are not into the data business per se.
Very interesting. Our next slide is about the service requirements and financial incentives, and I find this a little confusing.
Well, you can join the club. I do too, and so do legal scholars and ambulance chasers and IT experts. Basically, the business cannot refuse to serve an individual who's exercised their privacy rights under this new law. They can charge different prices based on different levels of service to individuals. But then here's where it gets confusing, but only to the extent that the difference is reasonably related to the value provided by the individual's data. I don't have any idea what that means, so hopefully our esteemed legislators will help clarify what that means. And also, if the business offers financial incentives to consumers to provide personal data, those consumers have to be notified, and there has to be an express opt-in for them to get in. And also, they need to be able to opt out of that program at any time.
I just realized that my Q&A window was closed and the window that was open was not pertaining to questions. So we have some questions we will come back to just to keep going with the momentum here. The next one, penalties and liabilities. It is so fun managing 3 monitors all at once.
It is.
There we go, penalties and liabilities. So at first blush, the penalties here look a lot smaller, but I'm going to imagine you're going to tell us that this is, there's a definition of per violation that I'm not going to like.
Yeah, you really won't like it. In California, nothing is ever easy when it comes to penalties. So yeah, if you have an intentional violation of AB 375, it can be $7,500 per intentional violation, per individual. That's an intentional violation. That would have to be pretty bad facts. Then there are penalties up to $2,500 per unintentional violation. There is a cure period that the company is allowed to cure the problem. But also, you see that third bullet, those are the really serious violations of credit cards, information, and other sensitive information. The Attorney General can can authorize civil actions, including class actions. So think about how many individuals might bind together and file a class action. And the damages, as you can see there, could be pretty substantial if you have 10,000, 20,000 individuals that are in that class. And criminal prosecution is even a possibility if there's a breach of the credit card or other sensitive information.
So I think the concept of breach, which means unauthorized access to that data, is something that we should talk a little bit more about. In my industry, and when I'm looking at the industry experts in IT, it is commonly published that most businesses do not become aware of a breach, unauthorized access to data, for months after it occurs. Sometimes we've seen these where it's been years after it occurs. And what I'm getting the impression is of both of these laws, you have a limited amount of time to make announcements, be aware, comply with these things. To me, this whole concept of breach speaks of control.
Yeah, the GDPR and also the California laws based on, after you have actual or should have actual knowledge of a breach, that's when the clock starts ticking. And the data breach could be the unauthorized release or transmission of personal data to a third party, Arguably, it could also be, let's say, the failure to respond to a request within 45 days. The question then becomes, well, how much damage has the person incurred, and do they have to give you, a 30-day cure period after that point? Some of these fine points, I think, are going to have to be clarified under the law. But it brings back, Ed, you talk about how a data breach might occur and the company doesn't know it. It gets back to that same issue of that company needs to step up its game a bit as far as monitoring what data it has and where it is and where it's residing.
Well, the whole awareness thing is, I'm a farmer's son. I grew up in the Central Valley, and it's kind of like the person who puts his horse in the barn and he can see the barn, and people say, "How's your horse?" "Oh, my horse is great." Well, you can't see the horse, you see the barn. Very often people see their computer infrastructure, but they don't really know what's going on in it. And kind of the ugly secret in IT is your IT people probably don't know either, unless it's a requirement of your support. And I'm talking about whether you're outsourcing it or you've hired people and they work for you as employees. Unless you make it clear that that's part of the job, and frankly, you query them on it periodically, it's probably not happening. And that's why we see this in the news again and again, where companies lose access, former employees do something bad with the data, somebody who wasn't authorized gets access to that data. It's often the company's the last person to know, because the people they put in charge of the hen-house aren't doing the job.
Yeah, the hen-house, after these two laws have come to the forefront and what's on the horizon, yeah, the hen-house is going to have to be strengthened with, I guess, more roosters around the hen-house to guard things.
Okay, well, let's talk about next steps a little bit. What should my company be doing now with the GDPR in place? And thankfully, the California law does not take effect until January 1, 2020.
Yes, that'll be here before you know it. The first thing is to determine whether you're even subject to the GDPR. Again, either as a data controller, where you're determining what's collected and how it's processed, or a data processor. Of those of you in the audience, or at least clients I work with, more often than not, if they're within the GDPR, it's often as a data processor. Same thing with the California Act. See if your company is subject to it. And if you're on the fence, particularly with regard to the GDPR, there are ways that you can get to the side of the fence that you want to be on. You may not want to be subject to the GDPR. It's important to remember that compliance with one of the laws doesn't mean you're in compliance with both. They're similar in concept, but they're quite different in places, and it really gets to the specifics. The next bullet really talks about what we've been discussing, is just making sure that you know where your data is and what is being done with it, where it's being stored, and so you can respond to these requests. Another important thing is to make sure that your contracts are updated to make sure that you're not inadvertently taking on more liability than you really should. If you're acting in the role as a data processor, kind of like a subcontractor again, you have to make sure that that data controller or the general contractor has primary liability, and that they will indemnify your company if your company gets pulled into a liability dragnet. And the last thing I'll just mention is really explore cyber liability insurance. If you're going to be doing data processing services for any substantially sized company, medium to large, they're going to require it, and it's a really good thing to have in place.
Regarding cyber liability insurance, I think it is today an amazing buy. It's really cheap. A year ago, it was even cheaper. Unfortunately, the insurance companies are starting to realize that everyone's getting hacked. The FBI has said several times that there's two kinds of companies, those that know they've been hacked and those that don't know they've been hacked. You really should go out and look at cyber liability insurance, especially while it's so cheap and affordable, because everyone will be hacked. The question is, are they going to get the goods that they're going after, or are we going to be able to keep them at bay?
The one thing I wanted to mention also, Ed, as far as, trends, what's next, the Google and Facebook and their big data trade coalition is in discussions, private discussions with the Trump administration about the possibility of having a federal data privacy law that would essentially preempt AB 375, which, makes some sense in the sense that it's difficult to deal with a patchwork of different state laws if you're in the data processing business. So stay tuned for that one.
Well, actually, that was going to be my next question. You jumped the gun on me a little bit. So we're seeing laws coming from individual companies or countries. We're seeing laws from individual states. And you're alluding to the fact that we may end up with a national rule here. What if other countries come up? I mean, what can you see coming in this area?
Well, the main thing, and you have to kind of go to a 30,000 foot or maybe a 50,000 foot level, you really have to focus on what are the key challenges. And in a number of really good articles that I've read by attorneys who spend a lot of time on these high-level issues, it really comes down to knowing what data your company has, where did it come from, where is it being stored, what are we doing with it, are we sharing it with anyone? That map, that data map is absolutely essential. If you have that in place, then you're probably going to be able to deal pretty effectively with any of the domestic US or international data privacy laws that come down.
Okay, let's address a number of questions that came in while we were doing all this. First one, by the way, Andrea, we love you. Lots of questions. We like questions. One question, can you send me a copy of the presentation link, please? We're going to make soft copies available of the PowerPoint and I believe the recording as well. So certainly you can have that. What if I don't have a website? Would I be excluded from this? And I think Alan's talked about that, but go ahead again.
Yeah, unfortunately, no. You could be subject to the GDPR or AB 375, even if you do not have a website, if you are using hard copy materials to market to people in the EU, for example, even if you're at a trade show and you have a booth, but it's evident that you are targeting people in the EU, you could also be involved with it that way.
We were asked to share a link to the GDPR. Alan had already included that on one of our slides, but for our listeners, it is https://EU-GDPR.org. Again, https://EU-GDPR.org. Next question, how does the AB 375 handle the processor versus the controller?
Unlike the GDPR, which addresses it very clearly, AB 375 doesn't get into a whole lot of detail about that. But definitely the way I read AB 375 and the prevailing view in the legal community that's coming up about this law is, yes, if you're a subcontractor and you're taking on the responsibility of the main regulated company who's subject to AB 375, likewise, you have to comply with applicable law. And when you think about it, it's analogous to, let's say, if you have an environmental consulting company and they are going to be doing some consulting services for a client, but they want to sub out part of those services to another, smaller environmental consulting company. That subcontractor has to abide by any laws that the main general contractor consulting company has to abide by. So there is a flow through. It's a similar, it's analogous to what currently exists.
Okay, well, we've answered the questions that are there now, but if you have a burning question, type it in. We're going to go to the closing slide, but if we see any more questions before we wrap up, we'll be happy to answer them. So I hope you enjoyed today. I learned a lot. In fact, one of the reasons we did this webinar is I wanted to learn more for my company, and they often say the best way to learn about anything is to teach. And so I was getting lots of confusing information on the web and talking to people, and I said, well, who do I know? Let's bring in the experts. So thank you so much. Again, all attendees will receive a copy of the presentation. As usual, we like to offer a free gift for participating in our educational webinars. Today, the gifts are quite substantial, particularly in Alan's part. Both he and I are offering free one-on-one phone consultations. Alan, Alan is giving an amazing offer, particularly when you consider the normal billing rates of lawyers. Alan is offering a free 45-minute one-on-one phone consultation to discuss your business, what questions you have around either GDPR or AB 375. That's really a phenomenal question. It could put your fears at rest or make you be thinking about next steps. For my part, I'm offering anyone on this call or webinar a 30-minute one-on-one phone consultation around your data security and or your data access controls. Because GDPR and AB 375 are both about the data you keep, we've talked a little bit about you must have strong awareness of that, where it resides, who has access to it, how it's backed up, where are all the places that it might be copied to, and how old are you retaining that information or how long. So you could take advantage of a one-on-one with Alan or me or both of us. We're just happy to do those things. These are both very significant offers, and I hope you'll take advantage of it. Looking over, I see no more questions, Alan. We've quieted them down. Anyway, thank you so much for joining us today. I know Alan and I both enjoyed this. Any final comments, Alan?
Ed, thank you for having me here today. It's just, I like to do whatever I can to hopefully remove some anxieties from company owners. And again, there are ways that you can move your company outside the scope of both of these laws, especially the GDPR.
Well, speaking for myself, at least, I feel a lot more informed going into this, seeing all the emails where everybody was offering to do this for me. Now I'm understanding, a lot of that was hype, and I have a much better understanding of where I go here forward from here. But thank you so much for joining us, and to all of our guests today, thank you so much for joining us on the webinar. Have a great day.